Hi, I'm Andrew McCrae. Welcome to our farm and ranch in northwest Missouri. My great-great-grandfather settled here in 1910, and I'm the fifth generation to grow crops and livestock here. As a farmer myself, I know the highs and lows of this life, the issues we confront every day, some new, some as old as farming itself. This show is a place to talk with farmers and others in the ag industry about topics that mean something to us, topics that can improve the present and future of our operations. This is Farming the Countryside. Ray Starling joins me on Farming the Countryside. Always good to visit with Ray. And Ray, for those that have forgotten, you're at the North Carolina Chamber of Commerce, but you may want to give them a little bit of background because certainly you have legal background, lawyer, but also worked in the White House for a bit.
Yeah, it's hard to decide which part to tell people, but there's got to be something in the resume that will make anybody mad. Yeah, I grew up, probably my best claim to fame is I grew up on a hog and tobacco farm down in southeast North Carolina, and I became friends with Andrew McCrae through one of the greatest youth organizations in the world, the National FFA organization. Was a national officer with that group after Andrew. I'll point that out. I'm younger than him. But after finishing at NC State, I got the itch to become a lawyer. And my career has mostly been around legal and agricultural policy work. And that gave me the opportunity to work in the U.S. Senate and at the White House and as chief of staff at USDA. And I'm very fortunate to be back in North Carolina at the North Carolina Chamber, where we're a little bit unusual because we're a statewide chamber of commerce, but we have a heavy ag focus because, quite frankly, it is the number one industry in the state. And it's a big part of our economy here. So lots of other things we can talk about, but that's the gist of who I am. Maybe a fun piece, Andrew. I'm now an aspiring blueberry farmer. I planted 70 blueberry bushes earlier this spring, and I believe 69 of them have made it through the summer that we've had, which was very wet for a while and then very dry for a while. So anyway, I can call myself a bona fide farmer at this point.
Well, that's the next topic. We'll get to blueberries then, I guess, the next time we have you
That's
on.
right. Yeah.
So, Ray, some people hear this and say, oh, no, they're going to talk about law stuff, and that's going to be boring. And I don't think it'll be boring, but people sometimes say, okay, what's it matter? But I know we've got some things that, and you always do a good job of saying, here's why this does matter. This is why a farmer should care about this. Let's jump right into it. I mean, we're hearing lots about tariffs. I know we have since President Trump took office here for the second time. But especially now, China at the forefront. We haven't sold beans, so this is a lot of banter in farm country. But I think one thing we forget is there's still a legal challenge behind these tariffs that hasn't been resolved. Speak to that and where we stand with those tariffs and whether the president has the authority to do so, make some of those tariffs.
Yeah, let me do a little run into that first, Andrew. One is to just thank you for the opportunity. Always great to visit with you. Number two, I thought you said a mouthful there when you said, we did some of this stuff can be boring. It can be, somebody else is worrying about that. That's just the legal stuff out there. But, I think we're in a point in our country where the courts are really playing an outsized role. And that's partly because Congress is not writing a lot of new legislation and offering a lot of clarification of existing legislation. And so each party seems to sort of wait until their guy is in the White House, and then they get what they want through the administration. And that really means that the only check on that authority, if Congress is going to act that way, the only check on that authority is to take the administration to court. And in fact, several of the cases, all of the cases, I believe that you and I are planning to talk about relate to parties taking the federal administration to court or challenging the federal administration in the action they've taken. That's exactly what's happened in this International Emergency Economic Powers Act case, IEPA, which you and I can refer to it from here on out. But this is basically a 1977 law that gives the president some authority. And of course, the question in the case is going to be how much, but some authority to regulate importation. And that's all it says. It never uses the word tariffs. And so the Trump administration has taken that language and at least in part, I mean, there's several different tariffs actually that are subject in the case, but part of them, the administration said that they imposed as a result of illicit substances coming into the country, and that this is an emergency, this is a threat, and we've got to do something about that. And then, keep in mind the name of the piece of legislation, emergency economic powers. The president can pull that lever of imposing tariffs to address that concern that he has. That's his argument, at least. And again, what the folks that are suing, which include some small businesses for whom the cost of business is going to be more. One of the cases is kind of interesting. It's a women's apparel company that I think sells sort of, exercise clothes. Most of those are, as you can imagine, manufactured outside the United States. And they're basically saying we cannot stay in business if these tariffs go into place. We simply cannot stay in the market. And so, the president is claiming he's dealing with this unusual and extraordinary threat. That's exactly what the statute says you have to have. But lots of interesting legal questions in the case about how far can he go in terms of regulating importation through tariffs. I'll say one more thing, and then you might want to jump in with a question. But one of the things I keep hearing the United States Trade Representative say, who happens to be a friend of mine, Jameson Greer, he's pointing out, and he's an attorney by trade as well, and a very darn good one. He says there's really not debate about whether the government or whether the president in this case could cut off the importation of a certain good, that clearly IEPA would appear to give him that authority. And so Jameson is quick to say, and I think in our filings, they're quick to point out, therefore, we should be able to put a tariff on it, to basically tax it, if we could have stopped it from coming into the country entirely. We'll leave it up to the Supreme Court. They've been fully briefed, but they have not heard oral arguments in the case. That won't happen until early next month. But that's kind of the rub of the case.
Yeah. You mentioned the Supreme Court's going to hear that and so forth. I want to look for a moment. I'm going to get off tariffs, but we can come back to it. As we think about these court rulings, and you said the courts have so much now to do with this, which obviously do. Every time we hear reporting on a case, we hear that judge was appointed by,
that's right,
Bush, Obama, Clinton, to fill in the blank. You're out there, you deal with these, and maybe your answer is going to be, it depends. How much difference does it matter who appointed those judges and what they're going to rule? Because that immediately seems to be the indicator. Oh, well, they're going to vote for Trump. They're not going to vote for Trump on this. Right. And it says vote for them in this case.
Yeah, a couple of things. I mean, one, somebody every year goes back and looks at cases that have been decided by the United States Supreme Court and talks about, could you have predicted these outcomes based on who appointed them? And the answer is always, almost always, no. I do think there's a small class of cases that we would put under the heading of political questions. It's just very clear that the cases we hear about, the 8 or 10 or maybe 4 or 5 during an entire term of the Supreme Court, when they are hearing, in excess of 50 cases, we hear about 5 of them, so about 10% of them, maybe a little more, maybe a little less. And so my first thought is we've got to practice caution when we come to that conclusion. But second, judges are human. And judges come to the bench, I believe, in many cases with not necessarily preconceived notions about how a specific statute ought to be interpreted or how a particular matter ought to be ruled upon that might come across their desk one day. But I do think they come to the court with a framework of how they plan to analyze things like statutory language, how much deference they plan to give to a state agency, what they think about things like standing. And that's just such a boring, hard legal phrase, standing. But in many cases, a case can be decided depending on whether the court feels like it's got the right parties in front of us. Do you have standing to be here? And frankly, I think in the last year or two, this Supreme Court has made it a little more difficult for certain parties to have standing. And so, great, simple question, Andrew. Try to catch me, try to get me in trouble. But my sense is that, yeah, sure, sometimes your maybe ideological borings may be more apparent, but you would be surprised how little that actually ends up being true, at least in a scientific sense, a data-driven sense.
So that said, then with this case on tariffs that will be in front of the Supreme Court, it sounds like what you were saying is the argument seems to be strong that the president would have that authority. And if you want to go down the road of, well, there are more Republican appointed Supreme Court justices and some certainly by President Trump, does that make it likely that they will support the president, that he has this authority, or what do you think?
Yeah, I think that's a fair lens. That's certainly understandable given where we are and given the nature of the political cases that come to the court. I think really this case will come down to be more decided on what are the views of the justices when it comes to statutory interpretation. So when the president is allowed to, quote, regulate importation, do we read more into that or do we read less? Do we put strictures around that? Is that a, quote, major question that the Congress should have explained more if they meant to give him this much authority? I think it is kind of the way they think of analyzing cases and the frameworks that they use to do that, as opposed to their political leniencies, if you will, to the extent that they may even have one. So, if you're asking me to handicap this one, I mean, I actually think it's a hard one. But what I sense that the U.S. Supreme Court is doing, and I think this is smart. I think it's hard. I think it's going to be hard for a few years. But I feel like what the Roberts Court is going to ultimately be known for in history is saying, hey, Congress, we're not going to bail you out of your mess. And so to the extent that you have a 1977 law on the books, a law that's almost 50 years old, that's never been interpreted this way, but it just loosely says the president has the power to regulate importation. If you don't think it means what the president thinks it means, you have an apparatus to fix that without resorting to the courts. And frankly, the same to us, right? We can go to Congress and petition them to change the law, tighten the law, change what those words mean, use different words. And so my sense is that I think it's going to be mighty tempting for the conservatives on the court, particularly, to jump in here and say the president can't do this when Congress could most certainly shore up that language or shrink that language on its own if it wanted to.
Let's talk about a couple of other legal matters, cases that I think are important. One out of Texas recently settled dealing with PFAS, and if we don't know what that is, you can explain.
Yeah, well, I'm not sure I can get I'm not going to try to bite off the actual terminology of PFAS. There's a shorthand, I think we call them forever chemicals. And these are just chemicals that bind in a certain way that they do not break down, at least not over a long amount of time. What I have to pause there and say, they do break down at some point, or else the things that we had stuck them to, like pots and pans that they weren't supposed to come off of, like fire retardants and chemicals, they apparently are moving. They apparently are not forever. Those bonds do break. Because we know that they get into our soil and they get into our groundwater and they move. And so a group of farmers out of Texas actually sued the EPA and said, you have not regulated this enough. You have violated the Clean Water Act because you have not identified the specific pollutants that we think are in the sewage sludge that we are spreading onto our land as a fertilizer, obviously. And so, they basically said to EPA, you've got to do more to regulate, in this space by identifying more of these chemicals and therefore creating the regulatory regime to do something about them. And a federal district court in Texas said, no, they don't, that he read the statute as requiring EPA to maintain a 2-year plan of governing sewage sludge. But they were not mandated to list or not list any particular pollutant by any particular time frame. And so I flagged this one partly because I think that result is interesting. A group of, obviously the facts are interesting. A group of farmers suing the EPA, but essentially saying, EPA, you have not regulated enough here. I mean, how many times do we do that? Sue the federal government and want them to regulate more. That's kind of the man bites dog piece of this case. But for the court to wash its hands of it, dismiss the case. Now, it was dismissed without prejudice, which means it could come back. It could be refiled. But long story short, it's the kind of thing to keep an eye on as farmers are trying to figure out where are we going to be in this PFAS conversation, particularly if we end up growing food on this piece of land and then somebody perhaps comes after us because there's PFAS in their crop, in their vegetables, in their grain, whatever. This is all to be decided, I think, in the course of the next 10 or 20 years, and there's going to be a lot of lawyers debating about what it means.
Yeah. The other piece that we talk about a lot is labor, and there's many different places that we could go with that. Talk to me for a moment about H2A, but then we might have a broader conversation just about labor and shortage thereof in some cases with H2A workers. But what's on your mind?
Yeah, well, I definitely want to get to that because I think the administration has done something that signals they get it, that we've got a challenge in the ag labor space. But there's a very fascinating case, and this one, Andrew, literally unfolded or sort of became more final today, October 17th, and it's out of the Third Circuit. Some farmers, a family farm called Sun Valley up in New Jersey, was sued by the Department of Labor for H2A violations. And quite frankly, I don't remember what the claims were in that case, but typically for the department to, go all the way to suing, there's a good chance it probably didn't look good from the outside looking in. And so we aren't talking about here in this case the question of did the farmer do this or that, but rather a procedural issue came up in the case that said, can the farmer be tried, if you will, or have a hearing before an administrative law judge, which is a creation of the executive branch of government, or is that farmer entitled to go to Article 3 of the federal government, to the judicial branch of the federal government, and have a hearing before a federal judge? And interestingly, what was decided was that, yeah, the farmer, because of the kinds of civil penalties that were involved in an H2A penalty case, the farmer was entitled to have his case heard, his defense, if you will, to the Department of Labor's claims. He's entitled to have that case heard before a jury of his peers. So essentially, he has he gets to invoke his Seventh Amendment right to a jury trial, given the nature of how the Department of Labor proceedings, not proceedings, but the nature of the penalties that the Department of Labor could impose. That is relevant to us, A, because it involves the farm, it involves H2A, it involves the Department of Labor, but that is a massive burden to DOL in terms of enforcement, right? That is going to change how they prosecute H2A cases. I mean, at a minimum, I heard a practitioner say today, this morning, this is going to cause, quote, endless headaches for Department of Labor enforcement. And I think that's right. I mean, jury trials are hard to run. They take a ton of attorney time. There's nothing shortcut about them. Judges, frankly, will do everything they can to try to get them to go away so they don't have to sit through them for a week or 2 weeks at the time. So that's an interesting case. But as you laid the groundwork, maybe some good news for agriculture in a time when it's kind of hard to find some given grain prices at the moment. But this administration, I think, recognized, particularly with their crackdown on undocumented or illegal, and I don't use those terms in a derogatory way. I'm always kind of nervous about what I'm supposed to say. I don't want to get canceled, but essentially folks that are working here without the appropriate worker authorization. We know that some of those people work in agriculture. I frankly think the illegal percentage number is overstated in the country. I don't think it's as high as many of the studies have suggested. But then again, maybe that's what all the farmers want me to think, right? That there's not quite as many as there is. But long story short, the most expensive part of our temporary and seasonal labor program, our H2A program, is the wage rate that we are mandated by federal law that we pay to foreign guest workers. We've complained about that in agriculture for a long time because we know there is not a ready and willing domestic workforce that is willing to do the agricultural work. In fact, this year, I think our H2A number will eclipse, if not get very close, to 400,000 guest workers in the H2A program. And so the administration has come out and said, we're going to change the way we set the minimum wage that you have to pay that guest worker. We're going to use a different set of criteria. We're taking a bigger and broader look at the impact on the American worker. And frankly, it's going to end up ultimately spelling relief for folks who use the H-2A program, because that cost of labor per hour is going to go down.
As you think about that labor market and guest workers, H-2A, and then others that may not have documents, what are you hearing out in the countryside? How short are we on labor, and how much has immigration enforcement impacted the availability of labor? I know it varies a lot depending on perhaps where you live.
Yeah, and I think I would sort of bifurcate the labor market into on farm. Well, frankly, I would bifurcate it into agricultural employers that have access to H-2A and agricultural employers that don't. And so many of our livestock operations that need year-round help, there is a way to get into H-2A if you're a livestock farmer. But if you're a dairy and you're milking 1,000 cows a day, twice a day, or whatever, and you're doing it 365 days a year, it's a little bit hard to explain the seasonal part of that operation, and therefore you might be disqualified or not be eligible to participate in H-2A. Similarly, on the processing side, right? I mean, North Carolina, I'm sitting in North Carolina today where I'm from, and we have a sizable poultry and pork industry here. We actually do just about all the processing for those two industries here for what we grow, and finding workers for those plants is always difficult. And so if you're a processor, and again, you have that year-round need, you don't have access to the H-2A program. And so I would say they're actually in worse shape than the on-farm farmer, labor demand. If you can't access H-2A, you're in a mess. And so it's hard to quantify it, but for me to look at you and say that the farmers across the United States were willing to go to the trouble of working with the federal government, getting a visa, paying for transportation, providing housing, and paying a lot of times a minimum wage rate of around north of $15 or $16. If farmers were willing to do all of that to bring in 400,000 workers in 2025 alone, that should give you a pretty good picture of how dire the labor demand is out there.
In the time we've got left, then, so much focus is on the enforcement. Is there any mechanism in which they're working to help agriculture be able to bring folks in and expand that workforce and get the folks that we need?
I think the challenge there is everybody seems to generally agree that expanding a guest worker program or is probably going to require Congress to be more active. And that takes us right back to where we started this conversation, which is, and we've all got friends there. I appreciate what they do. I know there are people in there fighting for us, but it just feels like this issue is never going to get done on Capitol Hill. And it's because it's hard, right? Not everybody agrees on how it ought to be resolved. We're very grateful for those people that have put a lot of time into trying to help. I know Chairman Thompson on the House Agriculture Committee, he actually appointed a study commission. It was chaired by a Republican and Democrat. They came up with over 20 fantastic, unanimous recommendations. They're trying to see if we can get some of those implemented into law, but man, it's hard. It's just a tough environment right now to get anything done on this.
No, it is. Ray, I'm always appreciative of the time, and always good to talk some legal issues with you. I hope all is well down in North Carolina.
Well, I feel like we're just getting started. It's a shame we can't talk about legal stuff even longer, but if you want to call back sometime and we'll talk about normal things, I'll be happy to do that. Good to see you, Andrew. Thanks for letting me be a part.
Good to see you.